if you stop the harm. If you stop adding to the nutrient load, eventually the river will cleanse itself. The lake is a much tougher proposition because it doesn't flush the way the river does. It holds and it collects. Time will help, but certainly not in my lifetime, perhaps not in yours. There may be chemical solutions. There may be things that can be done that would help re-clarify the water, and we'll search for those answers. One of the reasons we're asking for monetary damages, other than having a pool out of which to compensate our lawyers, one of the reasons that we're asking for monetary damages is for money to get those conservation easements and do what we need to do to reclaim the rivers and the lakes. And by the way, in terms of the attorneys, I tell every audience this if I remember it. We negotiated from November of 2001 until the summer of 2005, telling the industry all the way up until the summer of 2004 when we actually retained lawyers and we filed a lawsuit a year later. All the way up until 2004, if you will agree to remove from the basin the waste that cannot be used by the plants and to put that in a consent decree, we will not ask for a dime of damages. Not a penny. If you will agree to be responsible for the waste and put it in an enforceable consent decree, and they refused. I told them from day one, if you make me hire lawyers, we're going to ask for money damages because I'm not going to pay our lawyers out of tax money. If I have to hire them, you're going to pay them, not the taxpayers of the state of Oklahoma. We finally hired a law firm, several law firms, in the summer of 2004, and we filed our lawsuit in the summer of 2005. To date, we have spent nearly $16 million in experts, in the surveys that we did, in the testing, in the aerial surveys that we did, in the inspectors and investigators we sent to take the soil samples, and the laboratories that we utilized to test them. This has been a very expensive proposition. Every penny of that has been borne